in early. We're going to start with some few introductions. Before that, let me just try and pull up the presentation so we're guided and following timelines when we're doing the introduction. So basically, it's going to be a 1 hour presentation, and that's it. I'm trying to pull up my PowerPoint with Zoom. But let me just keep talking while I'm trying to do that. So welcome to the program. We're basically going to talk about the overview of GDPR and NDPR regulations.
You can share your co-host.
Yeah, I'm just trying to figure that out.
Okay. So click on the green button that is the share screen. You can share.
Okay, so what I have is record to cloud, breakout. Okay, share screen, yes. Okay, fantastic. Host only.
It's okay. The goal of Learntor, everything is a learning opportunity.
Okay, so I expect that it allows me, but it's still saying who can share, only the host.
Yeah, co-host.
Yeah, I know. I'm trying to see. Okay, I think I'm good.
Are you able to share now?
Yeah, sure. Yeah.
Brilliant.
So I just want to
well done.
Everybody see my.
You can put it in full slide mode.
Okay. Just 1 minute.
Carry on. Super proud of you.
So please, yeah. Okay. Thank you very much, Learntor. All right. Basically, we talk about the overview of GDPR and NDPR regulation and the critical warning against data breach. So before we start, it's been nice for us to introduce ourselves. So basically, to introduce ourselves, we'll just mention our name, location, and what our expectation from the training. After that, we're going to talk about meeting rules for this training to be nice and effective. This program is powered by Learntor. So we'll have a brief overview of Learntor and the vision and mission. Then we'll also have an introduction by Learntor as Self-Mercy, and also the trainer for the day, Ari. Then we'll go into question about today's topic. We have Q&A, then the most important part of the whole thing, feedbacks for us to get better and also to deliver better services to you. So I'll start with myself. I'll introduce myself, and every other person can introduce yourself. Please unmute yourself for this introduction. You can turn on your video. Just make it brief so others can introduce themselves in time. So my name is Belikis Orinyowo. I'm in Nigeria. I'm in Abuja. My expectation from this training, basically, I want to understand more about GDPR and also data privacy. As an HR person, I handle a lot of data, so I really want to know about data privacy and what I'm doing wrong and what I'm doing right now. So over to you, Chinyere, then we can all introduce ourselves in turns. Please unmute yourself and turn on your video, so it will be a nice interactive session.
Thank you very much, Belikis. Good evening, everyone. My name is Chinyere Oranugo. I'm in Lagos, and I'm just learning. I'm all about learning and just hoping to use it when the time arises, when the need comes. That person can go for it.
Okay. Just hold on. Okay. So Ayodeji. Hello, Ayodeji. Hello. Can anyone hear me? Yeah. Okay. Okay. Okay, Ayodeji is not there. How about hello? Yeah. Okay.
We have spent 10 minutes already, Belikis. We have already exhausted 10 minutes. Wow. So let's just bring on the speaker so I can just introduce because of time. Is that okay?
Okay, very, very okay, Learntor. I think we can just type in the comment box our name, location, and what expectation from the training. I think we'll take it from there.
Okay, so I want to really commend you, Belikis and Chinyere Oranugo, for this our resource people for Learntor Meetup. They are going to be the one to bring about our guests, and they are going to be the one reaching out to guests to come and facilitate any session. The goal of this meetup is to make sure that we create a learning opportunity every chance we get, because this is very important to our development. A lot of people are not aware in terms of a lot of digital skills and opportunity, and we are trying to create that awareness with regards to skills that are out there in the market. There are so many jobs springing up in data protection, data privacy. As you know, it's a big nuances right now in the market. And I have the singular honor of my boss. Is my boss. My boss. My boss, I have the singular honor of bringing to this platform my boss, Boje. It was the one I used to report when I was a business analyst. I will make presentations to him, he will give me feedback. And today I have him here on our meetup where we're talking about GDPR, data protection, privacy, from the agile perspective, because everything about Learntor is creating a learning opportunity for the Black person where you can scale and know that I can do this job. It's not something that is far-reaching. So I welcome to you a data protection officer, Boje. He sits as a secretary of what they call it?
European Association of Data Protection Officers.
Just carry on and introduce yourself. And over.
Okay. Hello, guys. Thank you all for joining. Like you don't know now, my name is Boje. My original background was from IT. I worked in IT for a bit before becoming business analyst, service transition analyst. And the last 6 years when GDPR came in, I saw a gap in the market and I decided to have training in it. And luckily I've been working in that field since now. I work for major organization, global organization. And my passion is to kind of push data protection, especially in the Nigerian context. With the Nigerian data protection, I want to help people to understand, putting myself in the position here when I was in UK at that time, when GDPR actually started, it was a way for a lot of people to get into what I call the corporate job. And I feel that will be the same thing in Nigeria as well. I think this is the time for us to start introducing that. And it's my pleasure to be here to just bring out my knowledge that I've got, just to share basically what I've got, because you learn also from others, not just from yourself. The more you bring out the knowledge, you know, the more you pick out from people as well. So it's my pleasure being here to just give an introduction of GDPR and NDPR.
Over to you. You can start. It's all your show.
Okay. I should start. Okay. So let me just share my screen.
And Chiere, well done.
Okay. Sorry, Learntor. I was just hoping you could just say one or two things about yourself.
Myself. I'm myself.
Okay.
Please.
But it's just nice to, at least we are having this because of Learntor. So it'd be nice to hear one or two things about Learntor.
Okay, Learntor is a digital consulting company that is focused on bridging the digital skill gap for Nigerians, hoping that we expand into Africa. Our goal is to make sure we create a learning opportunity for everyone, that's knowing that there is nothing you can't learn, there is nothing you cannot do. You can do anything that you set your heart to do. So this, I have the singular honor. I see that Marilani, a seasoned Agilist, enterprise Agilist, is on call. So Ari, over to you. I'm the worst person to introduce myself, but
okay. So basically today it's not a training per se, it's just an awareness, just to bring out the two regulations, data protection regulations that concerns both the EU and Nigeria in the context of how we protect personal data. So if we go into the training proper, It takes around four days basically to go throughout, where I'll bring scenarios of things. But today we'll not be able to do that. We'll just go through it and give people the opportunity to ask questions as much as possible. If I have the answer straight away, I will give you the answer. But if I don't have, I will go back and look at my own research and do my own research and come back to you. But I hope I should be able to answer at least, put it, give or take 90%, 95% of your question, if not 100%. So what is this? Sorry, what is this GDPR, EU GDPR? Let me just say here, you will come across also when you do your research, there's another version called the UK GDPR. Is similar to the EU GDPR. I mean, because of our training, we know why this is. It's just because the UK is no longer in the EU. Basically, that's the reason why. So the GDPR itself came into effect in 25th of May 2018. It applies to all organizations that have presence in the EEA countries. Either you have a presence in the EU, or you provide goods and services to the EU. Be it, for example, you are in Nigeria and you have your company and you provide services to the EU, then you need to comply with the GDPR regulation. Why the NDPR is taking, what I would say is just, I hate using the word copy. It's just, we take the inspiration from the EU GDPR. It's similar in some context. It came into effect in January 2019, to be precise, 25th January 2018. And it covers all people residing in Nigeria and outside of Nigeria. So this is where the Nigerian regulation, NDPR is slightly different from the EU GDPR. The EU GDPR is specific for EU residents. It doesn't mean you should be EU citizen. If you're a Nigerian, you are resident in the EU, it covers you. But in the case of NDPR, it's specifically for Nigerians in Nigeria and Nigerians outside of Nigeria. It covers them as well. Why GDPR, if, for example, somebody is a European citizen is resident in Nigeria, it wouldn't technically cover them because they are resident there and they abide to those local laws. So there are key definitions which we're going to be looking at both regulations. You will see now that what I say, both regulations are similar. Okay, so we talked about personal identifiable information. What that means is any information that will lead to the identification of a living individual. Okay, it's called personal data, like your name, your address, your date of birth, your possibly your IP address even. Any information like in the NDPR, we talked about that, like your SIM card, your MIS number, and all other informations relating to an individual. Okay, and data concerning your generic data, your biometrics data. You will know that we in Nigeria will collect a lot of biometrics data as well. Those are classified as personal data as well. Data subjects are individuals, people like yourself and myself. In the both regulation, they're classified as data subject. Okay, so you will hear a lot people using data subject. That is technically what is meant, yourself and myself. And this regulation gives the data subject some explicit right to determine how their data is being processed. Okay, this just kind of overview. When we do the full training, I will break into it, give examples and stuff like that. You see that data controller. In the NDPR, we have data controller as well. Who are the data controller? Data controller are those organizations or individuals that would determine the use, or that will collect and determine the use of those data that they've collected. So they are data controller. An example would be your banks. Bank are data controller. Your local authority, they are data controller, because you give them the information based on the services that they want to provide to you. And it's their responsibility to protect that data. And you as an individual, you have it as a data subject, you have a right to request some certain information from them as well. Personal data and personal identifiable information are the same. They use them interchangeably. Okay, so don't be confused when you see those terms. I see the PII as more an American way, but I would say data protection, personal data and personal identifiable information are simply the same. Data processing is any act that you carry out on a data set. So what do I mean by that? If an organization collects your data and store it in a database, and they are processing it to maybe send you information about maybe marketing when you've given the consent, or they want to just contact you generally, that is processing. Any activities you carry out on that data set is called processing. Okay. When we look at a data breach, you could see data breach or see personal data breach. They're the same. Data breach mean an unauthorized access to a data set, either being unlawfully or be it is being tampered with, it's become incorrect. Those are what we classified as data breach. Data breach could be as simple as you sending, as an organization, you sending an email to the wrong recipient, or most common human error is where you, instead of blind copying people, you copy everybody in an email. Okay, so that is also classified as data breach. Okay, consent simply means you are giving the right to that organization to process your data. Okay, and consent should be freely given. Okay, so you shouldn't give consent under duress. So that's why HR and an employee, so employee and employer's relationship is not always advisable to use consent, because it could be classified as not freely given, because the person might be scared that if I don't consent to this, I might get sacked or I might get punished. Okay, so data anonymization means you are rendering that data unidentifiable. What do I mean by that? So if I take your data set, if I take your information, your name, for example, and I replace it with maybe codes, so meaning you cannot easily use that to identify me as an individual. So in such cases, that is actually outside the scope of GDPR. Once those data is anonymized, that means you cannot use it to identify a living individual. When we talk about special categories of data, okay, and sensitive personal data, they're the same thing. Well, both regulations classified it differently. In GDPR, it's called special categories of data. Some places you will see them refer to sensitive data. Yes, most people get confused with this. Your bank details, your password, all those information are sensitive, but they are sensitive to you. In regard to this data protection, GDPR and NDPR, those are not classified as sensitive data. We have areas that topics that are classified as sensitive data. For example, any information about your ethnic origin, any information about your race, any information about your racial condition, and any information about your sexual orientation, anything about your biometric data, your health records. Those are what are classified as sensitive or special categories of data in both regulation. Sodomization means, yes, you can render that data, that you cannot use it to identify somebody immediately. So don't get confused with anonymization and sodomization. Sodomization, you can still use that to identify that a living individual, but however, you need to put some technical measures in place or some combinations of tools for you to be able to identify that person. So that's what we call sodomized data. And third party could mean simply any suppliers. So don't get confused. You see suppliers, vendors, and all that. They're all third parties. So anybody that act on behalf of the controller or provide service on behalf of the controller. Say, for example, here in the UK, your banks, you will see them sending you later. They will saying you can't. Yes, it seems as if it's coming from the back, but they must have employed some other third party to help them do that processing, to help them send those information out. So those could be classified as processor. So you might have third party. So organization can have hundreds of processors or third parties in the organization. So the key principles of the two regulations, again, you see the similarities there. We talked about transparency. What is transparency? Why we're talking about transparency? It's transparency in the regulations. I don't want to start quoting articles basically. So if you look at from Article 1 to 5, thereabout, it talks about your transparency. So it says meaning the organization have to be transparent with you with what they do with your data. Okay, so if they want to use your data for marketing purpose, if they want to use it for, say, if they collect it, they want to share it with somebody, they need to tell you what they're doing with it. And a lot of organizations have come up with supervisory authorities have fined organizations for not being transparent enough with their supervisory authorities, with their data subject. And one of the ways of you being transparent is in your privacy notice. So if you go to a website, I go to the very bottom of it, you will see privacy notice or privacy policy. If you click on it, you will read it, you will see telling you about when they collect your data, what they use your data for, who they're going to be sharing with, possibly how long are they going to be keeping those data for. Okay, they're letting you know, being transparent to say this is what we're going to use your data for. Okay, in lawful basis of processing. So both regulation gives this 6 lawful basis of processing. What that means is before you process any data, okay, you should have one of the lawful basis of processing, at least one of the lawful basis, and you can only use one at a time. What are these lawful basis of processing? We have processing, we have consent, we have vital interest, we have performance of a contract, we have legal obligation, performance of the public act, public tax, performing duties of a public task, and then you have your legitimate interest. Both regulations have those laws. So organizations will choose which of those lawful bases they're using to process your data at a particular time. So basically that processing activities, it could be maybe if it's marketing, they want to market things to you, it's most probably going to be consent they're going to use. Again, somebody was saying in HR, if you go back to your HR, you see that most of those processing that they're using performance of a contract that you are the data subject and the controller have gone into. Okay, so with the consent of your data subject, you need to, like we said, consent is one of those areas that is you have to give a consent. It must be freely given. It must not be ambiguous, and it must be a kind of affirmative action, either by ticking a box or by sending an email or by verbally giving a consent. And it is the responsibility of the controller to store those consent to ensure that, yes, have a proof that they collected consent from you before they process your data. Okay, again, I've talked about the protection of vital interests of the data subject. I mentioned one of those 6 lawful bases. So if, for example, somebody have medical emergency in case of life and death, normally you will go to need to get consent from either the data subject or maybe the doctors, or in a case here, you get the GP of that data subject. In such cases of vital interest, because that person's life is in danger, they can process those data, can access the person's data without getting consent from that person or the representative. So consent is, once it's in life and death situation, they might not wait to get consent. Say, for example, a pregnant lady, she's in labor, she's been in labor for maybe, God knows, 3 days or something like that. And the doctors have determined that we can no longer wait for maybe somebody, for the husband or so, to give consent that they want to operate, take her to theater immediately, because her life is in danger. They can rely on that vital interest. Okay, to comply with a legal obligation. So for example, a quick example would be your tax law in any country, your immigration law, for example, they stated there, for example, here in the UK, before you are employed, the organization need to prove that you have the right to work in the UK. So that is kind of a legal obligation that they need to comply with. Okay, so I'll talk about the vital interest. I think I put it there twice. Performance of a contract could be where both you organization as an employee, you employ somebody. It could be on that. Again, it could be public interest, could be your local authority providing services to you. They might not need your consent. Legitimate interest is a common one that is being used, meaning you're looking at the legitimate of the organization, the interest of the organization, and the interest of the data subject. But however, the right as an organization, if you're using a legitimate interest, your legitimate interest should not outweigh the right and freedom of the data subject. So you see there that you have to do what we call the legitimate interest assessment to determine if that is a lawful basis for you to process your data. Again, in the GDPR, local authorities are not allowed to use legitimate interest to process data. So in your NDPR, if you're reading the regulation, I will always advise you read the regulation, and then they have what they call the implementation framework. That for me, I mean, this is just me. There's some disconnect between the regulation and the implementation framework. The last implementation framework came out in November 2020. So if you're searching for that, ensure that you are reading the November 2021, because it gave more information on how to implement NDPR. There are sanctions in both regulations for non-compliance. So in GDPR, we have two tiers. So one is up to 10 million or 2% of the annual global turnover, whichever is greater. And then the most serious one is 20% or 4% of global turnover. Okay, these fines are discretionary and they are not that mandatory. So the supervisory authority, when I mention supervisory, I mean each country in the EU has a supervisory authority that monitors and take responsibility for data protection. So they might deem it fit to still fine you less than that, depending on the extent of the crime or breach, sorry, not crime, the breach that you've committed. Why in the case of NDPR, it's stated slightly different. Said in the case of a data controller dealing with more than 10,000 data subjects, payment of 2% of global turnover, annual turnover of the preceding year, or 10 million. Okay, so and then it went back to say the second category is when you process less than 10,000. So it's 1%. So you can see they try to want to align themselves with the GDPR, which makes sense, because there might be smaller organizations in the NDPR that process less data. Maybe it could be not even up to 10 million. How do you want to find those people? So those are the areas of sanctions under both regulations. Okay, so another key area again that I picked out here is the appointment of a data protection officer. Okay, the appointment of a data protection officer in the GDPR it's specified the kind of organization that should appoint a data protection officer. For example, if you are a public authority, a local authority, for example, in the judicial capacity, it should appoint a DPO. You process core activities, required large-scale processing. So large-scale processing, GDPR didn't define what large-scale processing is. It just means large-scale or systematic monitoring of individual. Okay, for example, online behaviors. So large case. So when you mean, say, for example, you are maybe the organization is like 30 people. worked in an organization that the workforce is 30, but however, they process high volume of sensitive data, health records. They process that, so therefore they had to appoint a DPO to be compliant with that. Okay, so it applies to both controller and a processor. While in the NDPR, it states that it is mandatory. Okay, it says it is mandatory that the data controller required to appoint a DPO. This is not too clear in this regulation, but having said that, in the new implementation framework, they've tried to explain it a bit, try to classify who should have a DPO. Okay, so you read both together, it'll give you more, but it just says you should have a DPO. Okay, so if the entity is a government organization, ministry, department, institution, also they must appoint a DPO. For example, they're performing core activities where they process, say, over 10,000. Again, you see here in the NDPR, they've specifically stating the amount of data that they think you should, when you're processing that, then you should have a data protection officer. The organization processes sensitive data, like I've given an example before. If you process sensitive data, then you have to appoint a DPO. Like in the GDPR, even its regulation advise you to appoint a DPO, even if you don't fall into those categories, because it will help you to be compliant or monitor the compliance of the organization. When we look at the tax of the DPO, you see what I'm talking about there. Okay, so the DPO tax is defined, for example, in Article 39 of the GDPR. For example, the purpose of the one of the responsibilities of the GDPR, DPO, is to inform and advise employees about the obligation when it comes to GDPR. So they will monitor compliance of that organization. They will advise the organization in terms of data protection law, raise awareness in data protection issues, for example, like things like your data breaches and stuff, and their responsibility to train their staff and conduct internal audits to ensure that they meet the requirements. Set up monitoring in terms of carrying out what we call the data protection impact assessment. I mean, we cannot go into that one. Data protection impact assessment is another 2 hours training. It basically means you are trying to identify the risk that a new process or a new technology, a new software that introducing into your organization, what is the impact? What is the risk to the data subject? Basically, that's what a data protection impact assessment is. The DPO will be the point of contact for the supervisory authority if they need to know information about the organization. If there's, for example, there's a data breach or there's a complaint against the organization, it is the data protection officer they will go to. So they are the first point of contact for either employee, customers, or the supervisory authority. Again, the supervisory authority cannot be dismissed or sacked based on the advice he or she has given. In our NDPR data, in this NDPR regulation, it was not originally stated. I mean, there's a bill going through Parliament now. Once that goes through, I think it will be more robust. But if we look at the implementation framework, now they've added it to say that the DPO cannot be dismissed based on the advice that he or she has been given. So if a DPO says, "Oh, this data breach is warrant us reporting to the supervisory authority," and insist on reporting, and he or she reports it, and then he is fired or she is fired because of reporting it to the supervisory authority, that will be breach of this Article 39 because he's been sacked, not because he's done anything wrong to the organization, but it's because of his GDPR activities that he's carrying out. That is why he's been disciplined, and it's against the regulation. Again, on the NDPR, it says also controller and processor must follow the regulation, comply with GDPR, appoint a data protection officer to cooperate with supervisory authority, work with data protection organization. We'll talk about, I'll touch on data protection compliance organization in the next slide. It's supposed to be data protection compliance organization. Sorry about that. It's called DPCO, and that is only particular to the NDPR. Okay, ensure that controller comply with the NDPR, do periodic auditing. So we do a yearly basis, we do audit and send a response or send a filing, like we the word they use, filing, send a filing to NIDA to say this organization is either compliance with the regulation or not. Okay. So I'm seeing some questions there. We'll answer this question when we come to Q&A question. Yeah, like I was saying earlier on, the data protection compliance organization, their responsibility. What is a data protection organization, compliance organization? In the NDPR, this is an organization that is a mandate that has been given to them by NIDA, which is the supervisory authority. So before you become a DPCO, you will need to apply to NIDA, and they will grant that. I think last time I checked, it's long ago now, we had about close to 100 DPCOs that organizations are supposed to engage with in order for them to be compliant with the regulation. Okay. The data protection regulation compliance and breach services for data control, they will monitor that. As a matter of fact, before the COVID struck, I was engaged in helping a local authority and 3 banks to be compliant with NDPR. So the data compliance organization will also try to provide training and awareness. They will be draft a kind of advisory contract for these controllers. Data protection and privacy breaches remediations plan. They will help the organizations to do that together with the DPO, internal DPO, to ensure that they are compliant with that, and information privacy audit. When we go to the training proper, we'll talk about what we call the auditing. In GDPR, we call it the record of processing activities, and in also the same, they call it record of processing activity. NDPR, what that means is you kind of taking a deep dive into an organization, understanding where they collect their data from, how they collect it, who they share it with, what do they do with it, and how long do they keep it with. So we'll talk about retention, but here we cannot talk about retention period because the both regulations specify that you set a retention period and the retention schedule. So if you say the bank is collecting your data and they will cease to process your data after maybe 3 years when you stop using that account, or you've said, okay, you want to close that account, they still have 3 years. So it depends on the organization. Each organization have their own retention period. So data privacy breach impact assessment is, again, you looking at the impact of your data breach. You need to report it. If you don't even need to report it, what kind of measures do you need to put in place? You've seen the risk. So what are you going to put in place to mitigate that risk? Okay, they would need to conduct a data protection privacy due diligence investigation. So due diligence meaning they basically looking at possibly the third party, they're looking at things that you have internally to ensure that they comply with the regulation. So it's all kind of interesting area to be in when it comes to the data protection and privacy field. So in some these are some certain data protection jobs that are out there. Okay. Again, the question is, do I need do I need to know what GDPR and NDPR is? Okay. So there are going to be a lot of jobs coming up, like I've said earlier on. It created a lot of jobs here in the UK. Back then when GDPR started, they envisaged that it was going to create 75,000 data protection jobs. And there are other jobs as well that's relating to data protection. For example, your business analyst, business GDPR business analyst, that's where I started from. So you are helping the organization to do what we call your gap analysis, helping them to put documentations in place and all that, engaging with other stakeholders. And then you have your GDPR project manager to manage the project or to manage their privacy program. Okay, Scrum Master as well, you get involved. Data analyst, again, your data analyst is where you, if you can hold your GDPR hat or data or your NDPR hat and you're a data analyst, then you will know that you don't need to share those data. You don't need to process those data that you're collecting unlawfully. Okay. There are a lot of GDPR job. I've done a search on some job sites in Nigeria, and there are a lot of jobs there. So it will, last time I checked, it said it will create over 300,000 jobs. Okay, and it could be business analyst, it could be big NDPR consultant, it could be a lot of GDPR, NDPR or GDPR related job. Now, since GDPR came into over 3 years old now or more, the job have become what we call business and usual now. So you will see now they say data protection manager, data protection consultant, or data subject access right analyst, free information governance manager. So things like that, but all around privacy. This is the time for me, this is the time for you to actually start to position yourself in the Nigerian market, because there are lots of jobs that's going to come there in no time, especially once that bill has gone through Parliament and it's become an act properly. Now it's currently, it was currently brought out because of the power invested in NITDA, which is the Nigerian Information Technology Department Agency, I believe. But when it becomes law and the awareness becomes higher, there will be a lot of jobs. There are a lot of international companies in Nigeria. There are a lot of local companies in Nigeria that need to comply with this regulation. They will be seeking people that have knowledge of this regulation. Okay, what are the certification parts if you want to certify as a data protection practitioner or expert? You could do what we call the EU GDPR Foundation and Practitioner. And I need to mention here the de facto certification or de facto knowledge around the NDPR could use the GDPR. So if you have experience in implementing GDPR, have knowledge of GDPR, automatically they take it that you understand that regulation, because from what few similarities that I've shared here, you see both of them are the same. They're going to be implemented differently. So you have what we call the Certified Data Protection Officer through an organization called PECB or the IAPP. The IAPPs will have what we call the Certified Information Privacy Professionals, which is CIPP. A lot of organizations here in the West will at least in the UK, will ask that you have a CIPP. And a CIPM is kind of a management program. You are managing the program for them, while the CIPT is more geared towards technology. It's still information, but it's still technology. A few that are there that I didn't put in here. There's one from ISACA as well. I think it's called Certified Data Protection Solution Engineer. It's all around data protection. So you can see if you are the ones that want to go the certification path, then you can take this path. I would say it doesn't necessary for you to have a certification, but it only just boosts your application. First of all, here, I think, no, let me rephrase it. I think in both the especially here in the UK and in Nigeria, here in the UK, it's your experience first before your certification. Why in Nigeria and America it's your certification first before your experience. Just so yeah. Okay, so I think let me just I've decided to do it for this short period so that we can have time to answer question, because I felt there might be a lot of questions coming in. What do I need to do and stuff like that. So I will hand it over to, is it Biliki that's responsible for this? And then we can start taking the questions.
Biliki will facilitate the question and answer session. This will be the end of the live broadcast. So the interactive session goes on the virtual floor. So let's ask questions, and I really love the picture. Biliki, it's over to you.